From the Library of Congress in Washington, D.C.
Today's program is presented by the John W. Kluge Center at the Library of Congress. The Kluge Center is a vibrant scholar center here on Capitol Hill that brings together scholars and researchers from around the world to stimulate and energize one another, to distill wisdom from the library's rich resources, and to interact with policymakers and the public. We offer opportunities for senior scholars as well as post and pre-doctoral scholars to do research in the Library of Congress collections, and we also offer free public lectures, conferences, symposia, and other programs, as well as administer the Kluge Prize, which is a recognized recognition for lifetime achievement in the humanities and social sciences. So for more information about the scholars in residence, the programs that we offer, and the fellowship opportunities for scholars, I urge you to take a brochure or a handout on your way out, and also to sign up for our RSS email list to receive future notifications about events and fellowship opportunities. All this information is on our website, loc.gov/Kluge, K-L-U-G-E. Today's program is titled A Teacher's Guide to Education Law, and our speakers are Jsv Blokhuis and Professor Jonathan Feldman. And they'll be discussing two new scholarly works that they've put out, Education Law 5th edition, which is this book, and which we have available on the way out if you're interested in purchasing it, as well as A Teacher's Guide to Education Law, 5th edition. And the books cover issues of student rights, discipline, negligence, discrimination, special education, teachers' rights, hiring and firing. They run the full gamut of issues. I urge you to take a copy on your way out. Jsv Blokhuis is an assistant professor of social development studies at Renison University College and University of Waterloo. And he's a 2013 Kluge Fellow. So he was a scholar in residence with us for 6 months during the course of this past year. 5 months earlier in the year and then 1 month returning in December. He is This newest books, newest projects are sort of born out of the research that he has done while he was here. And this is one of the most gratifying parts of the Kluge Center and the fellowships and residence that we have, is that when the scholars come back to showcase the scholarly works that they've produced and the books that they've written based on the research that they've done. And so Jsv joins a long list of distinguished scholars who have written and published works based on research here done at the Kluge Center and the Library of Congress. He has received his JD from the University of Ottawa and his PhD from the University of Rochester. And his areas of teaching and research include cooperative public education law and policy, children's rights, and custodial authority. Jonathan Feldman is a visiting clinical professor of law at Cornell University Law School. He received his JD from New York University School of Law. He has worked as a public interest lawyer for over 25 years, including 16 years at the Rochester office of the Empire Justice Center. And a note about the format of today's programs, our scholars will speak for about 10 minutes each, alternating 1, 2, 3, 4. That'll take us for about 40 minutes. And then we'll do a Q&A with the audience, with both the scholars in discussion, which I'll moderate. So without further ado, please welcome Jsv Blokhuis and Jonathan Feldman.
Well, thank you very much, Jason, and thank you everyone for coming today. This is a big book, and it would be hard to do justice to its content in 40 minutes, so we're not going to talk about every chapter in great detail, but a couple of chapters in some detail. I'll begin with the chapters that into which I suppose I put the most material from my research here. As a Kluge Fellow, I was working on a monograph project entitled Public Educational Authority and Children's Rights from a Parens Patriae Perspective. And some of that material found its way into chapters 4 and 5 of this book and the companion teacher's guide, Chapter 4 is Student Freedom of Expression, that's the title, and Chapter 5 is Student Discipline. And both chapters address legal issues relating to the regulation of student conduct in public schools. Teachers and school officials have a duty to maintain a safe and orderly learning environment, and at the same time, as they create and enforce school rules, they must be mindful of the fact that limited constitutional rights have been ascribed to students in public schools since 1969. The constitutional rights of students are not coextensive with those of adults, however, because most K-12 students are minors. And accordingly, public school teachers and school officials are agents of the state, for some purposes at least, and parental surrogates for other purposes. So I mentioned 1969. Well, it was in 1969 that Justice Abe Fortas penned 3 decisions, the most important of which, 1969, the Tinker decision, but that was one of 3 in that period toward the end of the civil rights era. In which the Supreme Court, through Justice Abe Fortas, repudiated the parens patriae doctrine, or at least appeared to repudiate it, and again, limited constitutional rights were ascribed to minors in custodial contexts generally. The 3 cases were Kent v. United States, In re Galt, and as I said, Tinker, and I'll say more about that now. The most important case for school law, Tinker versus Des Moines Independent School District from 1969. That was the case in which limited free speech rights were ascribed to students in public schools. And Justice Fortas wrote, quite memorably, First Amendment rights applied in light of the special characteristics of the school environment are available to teachers and students. And he added in a kind of rhetorical flourish, it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Now, this was 1969, and Tinker involved 2 high school students and a junior high school student who were suspended for wearing black armbands to protest the Vietnam War, and that was in violation of a rather hastily passed school rule. Justice Fortas found that banning this kind of symbolic speech violated students' First Amendment rights. He noted that the black armbands, or the wearing of those armbands, had not materially or substantially interfered with the requirements of appropriate discipline in the operation of the school, and this became the basis for what's now called the Tinker test, the material and substantial disruption test. Now this, again, 1969, Vietnam War, Civil Rights era, well, this was a time when many people believed that discrimination on the basis of age might be every bit as unjust as discrimination on the basis of race or gender. And throughout the 1960s, university campuses across the country were riven with protests and sit-ins and so on by college students opposed to the Vietnam War in general and to the draft in particular, and particularly the draft for young people who themselves at the time could not vote. School officials in Tinker sought to avoid that kind of disruption when they banned the wearing of those black armbands. In any event, in ascribing limited First Amendment rights to students in Tinker, Justice Fortas appeared to conflate pupils, minors, wearing armbands in middle schools and secondary schools with students, college students, agitating on campuses around the country. And this conflation was perhaps understandable because until a few years later, at least in 1969, the age of majority was 21. So Justice Fortas did not explicitly define what he meant by the special characteristics of the school environment in Tinker. Instead, he cited a canonical statement, or what might be regarded as a canonical statement, by Curtis Shears in the American Bar Association Journal, published several years earlier. Shears wrote, "The basic right of a juvenile is not to liberty, but to custody. He has the right to have someone take care of him, and if his parents do not afford him this custodial privilege, the law must do so." It would have been reasonable for Justice Fortas to assume, I think, in 1969, that most legal practitioners would understand that the special characteristics of the school environment meant or was a reference to the custodial relationship then existing between public school teachers and students. In any event, the Supreme Court began retreating from Tinker and, in fact, the Kent and Galt decisions almost immediately after Justice Fortas resigned later in 1969, in fact. And over the next 2.5 decades, both the parens patriae doctrine, the idea of the state having parental responsibilities to children, and the associated in loco parentis concept would regain at least some of their former currency as the court began identifying exception after exception to the Tinker test or the Tinker standard. So as we note in Chapter 4, beginning in the 1980s, a more conservative Supreme Court limited the scope of Tinker by identifying 2 circumstances when the material and substantial disruption rule did not apply. First, the first exception was that in a school-sponsored context, such as a school assembly or a school newspaper, the leeway that school teachers, school officials would have to regulate student expression would be greater than what might be termed independent student speech, and that's how we describe the dichotomy in this chapter. And secondly, the court began to recognize certain categories, additional categories of speech that did not enjoy the protection of the First Amendment in schools. So I referred to student assemblies and to student newspapers. Well, there are specific cases that are fairly well known in education law, and of course we discussed them in Chapter 4. Bethel School District v. Fraser from 1986, and Hazelwood School District v. Kuhlmeyer from 1988. In these cases, the court emphasized that the constitutional rights of students in public school are, quote, not automatically coextensive with the rights of adults in other settings. Hence, student speech that does not meet the disruption standard from Tinker need not be tolerated if it's inconsistent with the educational mission of the schools, and lewd or indecent speech at school, this is from the Fraser case, or speech bearing the school's imprimatur, as was the Hazelwood case. In recent years, what have we seen? Well, this very year, BHV Easton Area School District, it's added to the 5th edition. The U.S. Court of Appeals for the Third Circuit ruled that students could not be banned for wearing those I love boobies bracelets. Under the indecent standard, indecent speech standard from Fraser, or the Tinker standard, material and substantial disruption. The court determined that because a breast cancer awareness campaign couldn't be lewd. A national cancer awareness campaign could not be lewd under Fraser, and it didn't and hadn't. It couldn't substantially disrupt the school environment. Through the 80s and into the 90s, the Supreme Court continued to invoke the quote, special characteristics of the school environment, the language of Justice Fortas and Tinker, without explicitly stating what Justice Fortas had merely implied. But that did change in 1996 with Vernonia School District v. Acton. So that's a case that involves a 7th grader whose parents on his behalf challenged the constitutionality of a school policy mandating random drug testing for interscholastic athletes. It was Justice Scalia who explicitly characterized the school environment in that case in terms of the relationship between public school teachers and pupils, describing it, in fact, twice, describing it as custodial and tutelary. He wrote, "The legitimacy of certain privacy expectations vis-a-vis the state may depend on the individual's legal relationship with the state. Central, in our view, to the present case is the fact that the subjects of the policy are, number 1, children or minors, who, number 2, have been committed to the temporary custody of the state as schoolmaster." And then he cited American Jurisprudence, Section 10. Traditionally, at common law, and still today, unemancipated minors lack some of the most fundamental rights of self-determination, including even the right of liberty in its narrow sense, that is, the right to come and go at will. They are subject, even as to their physical freedom, to the control of their parents or guardians. And since Vernonia, the Supreme Court has in fact consistently invoked Tinker on one hand and deployed Scalia's phrase custodial and tutelary in cases in which constitutional or statutory rights claims have been raised by or on behalf of students in public schools. including Davis v. Monroe County Board of Education v. Earls, Morrison Frederick, of which I'll speak in the next 10-minute interval, and Safford Unified School District number 1 v. Reading. So we see this language of custodial and tutelary relationships repeating since 1996. Well, I'll take a break there because it's probably been 10 minutes and turn it over to my co-author, Jonathan.
Thank you, Jason, and thank you, the other Jason, too. I'm going to quickly talk about Chapter 7 and Chapter 9. The thing that really links those two chapters is a very recent federal law that was passed that expanded the reach of the Americans with Disabilities Act. It just went into effect in 2009. A landmark civil rights bill. Really, it's known as the ADAAA, the Americans with Disabilities Act Amendments Act. And it affects, in Chapter 7, we talk about students with disabilities. In Chapter 9, we talk about teachers and school employees. So it expanded the rights of both of those groups to the extent that it expanded eligibility under the ADA. And it's interesting to note, when we look at some of the major federal legislation that's been passed over the years, the Rehabilitation Act of 1973, known as Section 504, that was signed into law by President Nixon. The Individuals with Disabilities Education Act of 1975, the special ed law that as we call it, that was signed into law by President Ford. And the ADA itself was signed into law by President Bush Sr., and the ADA Amendments Act was signed into law by President Bush Jr. So, and these are considered to be fairly liberal civil rights laws, and yet it's interesting to note that they were all signed into law by Republican presidents. So what does that mean? Well, it means that not necessarily that they're conservative laws necessarily, but I think that there's been a lot of bipartisan support for expanding the rights of people with disabilities over the years on both sides of the aisle. However, it hasn't always been peaches and cream. There's been one entity that's been somewhat not quite on board in all these developments, and that's been the Supreme Court. The Supreme Court narrowed the reach of the ADA in a series of decisions. First, a trilogy, which is 3 cases that decided together, called the Sutton Trilogy. In that case, the Supreme Court introduced the idea that if you had a disability, but it was essentially under control or with a mitigating measure, such as medication or some other thing that corrected for the disability, then you did not qualify under the ADA. You didn't truly have a disability. That sounds reasonable, except it wound up throwing a lot of people off of the disability train, I guess you could say, who we would think did have a disability. And just to give you an example, in those cases, there were pilots for United Airlines who had 20/20 vision, but United passed a rule saying they had to have 20/20 vision without glasses. So they said, well, you can't discriminate against us because of our vision. The Supreme Court said, sorry, because your vision is corrected with this mitigating measure of your glasses, you don't qualify under the ADA. So it's sort of a catch-22, and so you can be fired. And that had more draconian types of applications. There was also a truck driver who had high blood pressure, but it was corrected with medication, and the Supreme Court said, yes, you don't qualify either, you can be fired. And even someone who had no vision in one eye, but was able to correct for that through his own just devices, the Supreme Court said, no, you don't have a disability either, even though you only have vision in one eye. The Supreme Court went, in another case known as Toyota, a worker who developed carpal tunnel syndrome and could no longer perform her job, was found not to have a disability, so she could be legitimately fired under the ADA because the Supreme Court said she could do basic household tasks like brushing her teeth. So Congress, in reaction to this, said, wait a minute, that's not what we intended when we passed the ADA. We didn't mean for it to be so narrowly construed as to who had a disability and who did not have a disability. So we are going to overrule the Supreme Court and say that these people are covered. Well, you might ask, how can Congress overrule the Supreme Court? Doesn't the Supreme Court have the last word? And the answer is yes, but only in matters of constitutional interpretation. This is just a federal law that we're talking about, and Congress has the final say in interpreting federal laws. So Congress did that in the ADA Amendments Act. It said to the Supreme Court, we disagree with your interpretation of our intent. We always intended the ADA to be construed broadly, and so we are overturning all of your decisions that construed it more narrowly. So now the ADA has a very broad reach, and just a few examples of how that applies. In the textbook, we talk about how this affects students with disabilities. First of all, there are three examples of how this might expand eligibility for students with disabilities. First of all, think of all the students who have a disability that's basically under control with medication. For example, students who have ADHD and might be taking Ritalin or Strattera, something that basically allows them to function well without symptoms of ADHD. Under the Supreme Court's old definition of the ADA, those students did not have a disability, so they didn't qualify for any accommodations. But now the Supreme Court said, we don't look at what medication you're taking and whether that erases your disability. We look at your disability without the medication, and so all of you kids who have ADHD, you're all covered. So now schools arguably have a much bigger hurdle and burden to make sure that all those kids are entitled to accommodations. Secondly, and this is really very important for certain kids who have, for example, very severe peanut allergies. In the past, the Supreme Court also had held that you don't measure disability when it's in remission or when you don't see evidence of it. So with a peanut allergy, if you never get exposed to a peanut, you're basically fine. You don't have a disability, according to that old definition. But now Congress has said, we're going to look at a disability when it's in its active state. So even if you only eat a peanut once in a blue moon, we're going to look at your disability for when you're eating the peanut. And so you do have a disability at that moment, and therefore you are covered. So that means that all these students who before were considered not to have a disability now are, and they all are entitled to accommodations, which might mean making a peanut-free schoolroom, a peanut-free cafeteria. So it does have big ramifications, especially for students, but also for the schools that have to make sure that these things happen. And finally, the courts are also looking at more unusual conditions as disabilities, and that's Congress has told the courts to do that, to construe disability broadly. So for example, in the textbook we describe a very recent case where a girl was expelled from a private school. Allegedly, her parents alleged it was because she had an eating disorder. And the school argued in court, well, even if we did do that, an eating disorder is not a disability. But the court said, well, under the new definition of the ADA, it might well be a disability. We're supposed to construe this broadly, so it refused to throw the case out. So that's, in a nutshell, how students and schools are now covered in a much broader way under the ADA. And of course, the same thing holds true of school employees. And in fact, the Amendments Act was really enacted with workers in mind, even much more than even students. So workers, teachers, school employees, similarly have a much greater protection under the ADA than they had before. So this means, again, the EEOC, the Equal Employment Opportunity Commission, has drafted regulations which spell out which disabilities, which might have been thought to be sort of questionable disabilities in the past, are now very much covered under the ADA, such as multiple sclerosis, post-traumatic stress disorder, and even obsessive compulsive disorder. These are all legitimate disabilities now. So if a school employee, such as a teacher, has a disability of that sort, they now have the protection under the ADA, and they can't be fired by the school district for having that condition, and they also, even more importantly, are entitled to accommodations to allow them to keep working in the school environment as long as they can still perform the essential functions of the job, and of course that hasn't changed. All this law did was expand eligibility. It did not change the rule that you have to be able to meet the essential functions of your job to be able to continue in it. So I think I will, that's my segment for now, and I will continue in a few minutes after Jason goes back to his segment.
Oh, thank you, Jonathan. Well then, let's see. Where was I? Oh, yes. I left off with a list of cases, decisions in recent years in which the Supreme Court has affirmed the nature of the relationship between public school teachers and students as custodial and tutelary. And I think it's important to note that it's been both judges that are regarded as generally conservative, but judges not so conservative as alike that have characterized the relationship in this way. So in Davis v. Monroe County Board of Education, this was a case that involved a fifth grader sexually harassed over an extended period of time by a classmate. Her mother filed a Title IX suit against the school district, arguing that school officials knew of the harassment but had done nothing to stop it, effectively depriving her daughter of equal access to the school's educational program. Noting that the nature of state's power over public school children is custodial and tutelary, permitting a degree of supervision and control that could not be exercised over free adults, Justice Sandra Day O'Connor found that because school districts exercise such control over students, including those known to be engaged in systematic sexual harassment of other students, that the district could indeed be held liable. In Board of Education v. Earls, a case from 2002, the Supreme Court upheld a school district policy mandating drug tests for all students involved in all kinds of extracurricular activities, not just athletes. Writing for the majority, Justice Clarence Thomas noted that Vernonia did not require the school to test a group of students most likely to use drugs, but rather considered the constitutionality of the program in the context of public schools' custodial responsibilities. Evaluating the policy in this context, he concluded, we conclude that the drug testing of students who participate in extracurricular activities effectively serves the school district's interest in protecting the safety and health of its students. Well, then came Safford Unified School District v. Reading from 2009, and this case involved a seventh grader who was strip searched by school officials looking for, of all things, ibuprofen pills. Writing for the majority, Justice David Souter found the search unconstitutional, but granted qualified immunity to the district on the ground that school officials had not violated any clearly established law. Concurring in this result, Justice Clarence Thomas reiterated his call in Morse v. Frederick, for a complete restoration of in loco parentis in schools. It's not something that I support, by the way. Well, what is this Morse and Frederick case? You might know it as the Bong Hits for Jesus case. It's better known by that name. It's from 2007. And this case was at least somewhat anomalous for a number of reasons, and I'll go into that, I suppose. This was a case in which an 18-year-old student unsuccessfully claimed that his school principal, Deborah Morse, had violated his First Amendment rights when she suspended him for hoisting a banner on a sidewalk outside the school, and the banner "Bong Hits for Jesus." It was at an Olympic torch relay. So what people tend to overlook in this case is that Joseph Frederick was 18. He was an adult when he unfurled that banner. And any other adult in Juneau, Alaska was at liberty to hoist a similar banner in the same city in the same day. But Morse, the principal, could suspend Frederick for doing so without violating his First Amendment rights, because Frederick was cast by, in this case, Justice John Roberts, Chief Justice John Roberts, as a student promoting illegal drug use at a school-sponsored event, and thereby carving out a new category of unprotected student speech, in this case, the promotion of illegal drug use, alongside long-standing excluded categories, obscenity, fighting words, threats, defamation, and so on. So you have this new category of promoting illegal drug use in a school context. To my mind at least, the jurisprudential problem here is that Frederick was not subject, at least not presumptively subject, to the custodial and tutelary authority of the principal by virtue of his minority status. He wasn't a minor, he was an adult, and thus voluntarily subject to school rules. Had Joseph Frederick wished to avoid his suspension, he could have simply dropped out of school and completed his studies elsewhere. As an adult, moreover, and this really gets to the heart of the matter for me, as an adult he had standing in his own right to sue the school under Section 1983, the federal statutory tort claim for alleged violations of his constitutional rights. So Section 1983 is a federal statute created to create it creates a cause of action for damages in tort against state agents who violate constitutional and various other rights. So in the Morse decision, the Supreme Court determined that speech advocating the use of illegal drugs in schools falls outside the scope of the First Amendment. It's a categorical exception. And there's no need then to apply the Tinker test to determine whether there had been material and substantial disruption. Principal Morse could therefore suppress Frederick's speech without violating his First Amendment rights, and Frederick was therefore not entitled to damages under Section 1983. Lost the case. Now, it's not that it's not the Section 1983 element that makes the Frederick case unique, the Morse and Frederick case, because in fact Earls and Davis and Safford and even Tinker in 1969, these were all Section 1983 cases. But what distinguishes Morse v. Frederick from the others is that Frederick himself had standing to raise these Section 1983 claims, while in all the other cases it was the parents or litigation guardians that raised the rights claims, Section 1983 claims on behalf of their minor children. So what's anomalous here? Well, it's that the Supreme Court on one hand recognized Frederick as a competent adult for juridical purposes. He had standing to raise these claims as an adult, while at the same time treating him as a minor, a pupil, subject to the custodial and tutelary authority of the school principal. I would say he was voluntarily subject to school rules, he'd voluntarily broken them, he should have accepted the foreseeable consequences of his choices, as would be expected of any other normal adult. At a minimum, Morse is probably not the most appropriate occasion for Justice Thomas, once again, in a concurring opinion, to argue for the complete restoration of in loco parentis in public schools. And it's probably not the most appropriate case for the Chief Justice writing for the majority to affirm, once again, the custodial and tutelary relationship between public school officials and students, because in this case, the student was not a minor. But again, we'll turn to American jurisprudence. We have Section 315. In American jurisprudence, teachers in public, private, and parochial schools all stand, to some extent, at least, in loco parentis to minors, to pupils. And the entry in American jurisprudence reads, a teacher is responsible for discipline in the school and for the progress, conduct, and deportment of his or her students. He or she, to a limited extent at least, stands in loco parentis, in the place of a parent, to the pupils under his or her charge. At common law, one standing in loco parentis has the right to moderately chastise for correction a child under his or her control and authority. Thus, a teacher may exercise such powers of control, restraint, and correction as may be reasonably necessary to enable the teacher properly to perform his or her duties and to accomplish the purposes of education. In any event, since Morse v. Frederick, federal courts have applied what might be called the Morse doctrine. So in recent years, we see cases like from the Eastern District of Pennsylvania in 2008, a case called Miller v. Penn Manor School District. This case involved a student who wore a T-shirt to school bearing the image of an automatic handgun with the imprint Volunteer Homeland Security. And between volunteer and Homeland Security, on the back of the T-shirt, there was it said "Special Issue Resident Lifetime License United States Terrorist Hunting Permit Number 91101, no bag limit." Then the school prohibited the T-shirt under the Morse Doctrine, not because it was advocating illegal drug use, but effectively carving out another broader category of promoting illegal activity, in this case vigilantism or perhaps even murder. The material and substantial disruption test from Tinker lives on, however, and this is an issue that's quite topical nowadays, cyberbullying. This is a form of off-campus speech, typically, targeting students or school officials. Now, this has become a major concern for teachers, parents all over the country. And we see various pieces of legislation throughout the country, and the federal government has also issued some reports defining bullying, for example, as, quote, a repeated pattern of aggressive behavior that involves an imbalance of power and that purposefully inflicts harm on a victim, adding that bullying, quote, assumes a variety of forms, including direct physical or verbal actions that cause physical or emotional distress, or, for the purposes of cyberbullying, indirect acts of social aggression that are used to damage a victim's personal relationships or social standing. So, what happens when schools try to regulate student speech in the form of off-campus speech, cyberbullying, social media, and that sort of thing? Well, the Tinker test applies. So the courts have to determine whether cyber speech, something that's communicated by a student through social media, caused material and substantial disruption in the schools. And in fact, courts throughout the country, not uniformly, but to a large degree, many courts have not hesitated to conclude that these requirements are in fact satisfied, especially, not only, but especially when cyber speech, cyberbullying, includes true threats. So words or images that threaten violence or depict violence against teachers or students. So we've got a couple of cases in Chapter 5, including Kowalski versus Berkeley County Schools, a case from 2011 from the Fourth Circuit. In that case, a high school student created an insulting and vulgar MySpace profile about a classmate whom she described as a slut and a whore, someone, quote, infected with herpes. The court found the district acted, these are quoting, the court found the district acted within its authority to discipline the cyberbully, noting that the profile created actual or nascent disorder, and that had the school not intervened, and these are the court's words again, the potential for continuing and more serious harassment of this student as well as other students was very real. Courts have been more reluctant to permit the discipline of students for cyber speech, cyber attacks that don't involve true threats, at least those that don't involve true threats against school officials. So we have the case of Jsv Blue Mountain School District from the Third Circuit in 2011, and this was a case in which a student created a fictitious MySpace profile, yet again, MySpace, of her school principal from her home computer on a weekend. And this profile contained extremely vulgar language, I won't repeat it here, and sexually explicit content. Well, in this case, the Third Circuit Court found that the lewdness exception didn't apply from Fraser. So yes, it was lewd speech, but we can't apply that here because this is off-campus speech. And that the Tinker standard did not apply because there had been no substantial disruption in the school. Well, the same circuit, the Third Circuit, likewise applied Tinker to decide in favor of students, again, in a case called Layshock v. Hermitage School District, also in 2011. And in that case, the plaintiff had, yet again, created an online profile of the school principal in which he was characterized as a drunk who used steroids, among other things. The profile was ultimately viewed by most of the students in the school in this case. And what's different here, the plaintiff used a school computer not to create, but to access the profile to show to other students in the school. So in response, the school had restricted access to the internet generally across the board. at least until the IT coordinator for the school returned from vacation and subsequently blocked access to that specific site. So there were rules put in place in the school that limited access to the internet and to computers generally. Nonetheless, the Third Circuit found that there had been no material and substantial disruption. An exception, well, there is a case also from 2011 that we feature in Chapter 5. Students using electronic media to promote or foment opposition to school officials or school policies. These sorts of things have not been tolerated. So in Doniger versus Nijhoff, this is a Second Circuit case. A student used an online blog to encourage other students to write to, contact, email school officials, whom she referred to as douchebags, to complain about the cancellation of a music festival. And in that case, the court found that there had indeed been material and substantial disruption, noting that students throughout the school had been, quote, all riled up, and that school officials had received, in response to this appeal, school officials had received, quote, a deluge of calls and emails. So I'll leave it at that and turn it over to Jonathan yet again.
And I'll try to be brief, because I know we want to have some time for Q&A. That's okay. Sorry, fine. So before we were talking, picking up where I left before, we were talking about the civil rights of people with disabilities. We have similar themes in Chapter 6 regarding civil rights based on race, gender, or national origin. So I'm going to very briefly talk about a very recent case at the Supreme Court level, Fisher versus University of Texas. It was decided in 2013, really just a few months ago. And this is a higher ed case. Our book primarily focuses on K through 12, but it has implications for K through 12, so it's still relevant for our discussion. This case addressed affirmative action in college admissions. And in any affirmative action cases, we have to start with the understanding that the Supreme Court has interpreted the Constitution to mean that any time the government uses race for any purpose, even if the aim is not to discriminate based on race, but simply to promote diversity, it triggers what's called strict scrutiny by the courts. That means that the government has a very heavy burden to justify its use of race. It has to show that there's a compelling reason to use it, or the program will be declared unconstitutional under the Equal Protection Clause. Again, even if the aim is a good aim. But in higher education cases, the Supreme Court has acknowledged that the attempt to foster diversity in the student population is a compelling interest, which can justify the use of race. Leaving diversity among faculty members, that's more of an open question, but at least for the student body, it has been held to be a compelling interest. However, the Supreme Court has held that when government does use race in college admissions, it has to do it in a very nuanced way, a very holistic way. It simply can't do it in a mechanistic way, which means, okay, we're going to assign 20 points to this student because this student happens to be Latino or Asian American. It has to sort of look at the overall portfolio of a student, and race can be one of the many things that it considers, but it has to be done in a holistic way. So in the Fisher case, this recent case, the Supreme Court applied those principles to the University of Texas system. Texas had a very interesting college admissions program for its state schools called the Top 10% Law, which guaranteed admission to any high school graduate who finished in the top 10% of his or her high school class. Arguably, that was a race-neutral program because it just looked at how you did in high school. It didn't look at your race. At least arguably, it was race-neutral. And 80% of all students in Texas were admitted to UT, University of Texas, through the system. So it did lead to some greater diversity, but not what University of Texas was seeking. So it adopted a second tier of admissions where it did look at race beyond this 10% law. And arguably, it used a holistic method for looking at race. So arguably, that would be held to be constitutional. But Abigail Fisher didn't see it that way. She was a white applicant who was rejected by the University of Texas, and she sued UT saying that she had been unconstitutionally denied admission because they looked at her race. So this case really turned on the meaning of the 10% law. And there are three different ways that it could be looked at. And lawyers love to look at things in different ways. So there's at least three ways it could be looked at. First, from the plaintiff's perspective, she argued that the 10% law was a race-neutral law that was working. So since it was working, there was no reason or justification to move to the second tier where you'd look at race. UT should have just stayed with a race-neutral part, and she was a victim, in her mind, of this second race-conscious approach. But from UT's perspective, this argument was essentially no good deed goes unpunished. They had used race-neutral means to the greatest extent possible. 80% of students were admitted in a race-neutral way, but they still didn't achieve the diversity they were seeking, the critical mass of diverse student body that they needed, so why shouldn't they be allowed to have this second tier of admissions? And the third approach finally came from Justice Ginsburg's dissent. She contended, this is interesting, that the 10% law was not race neutral at all. It was actually race conscious because it was predicated on the recognition that the high schools in Texas were extremely segregated. You couldn't be guaranteed of a diverse student body unless you had some high schools in Texas that were virtually all white and some high schools in Texas that were virtually all non-white, because you were sort of, the legislature knew that the segregated system would yield graduates that would basically be diverse, but only because you had that segregated system. So to Justice Ginsburg, the program to begin with was race conscious, but ironically, she thought that was fine because she maintains that race conscious admission plans are totally justified if they're done to promote diversity. So there you have it, three different ways of looking at it. The decision itself was somewhat anticlimactic. The court didn't really make any waves. It didn't get rid of affirmative action in college admissions as some had predicted it would. It just reaffirmed the existing principles that I mentioned earlier, that UT had to use a holistic approach to race, and it sent the case back down to the lower courts to make sure that UT had actually analyzed the case according to these existing principles. So it's good news, I guess, for colleges that want to still promote diversity because they can still continue to do so. It's also good for school districts that want to voluntarily promote diversity in their programs. And our chapter focuses on the implications of the Fisher case for those sorts of situations. Yes, school districts that want to voluntarily promote diversity within their borders can do so, but as a practical matter, it's much more difficult to have a holistic approach to race-conscious admissions when you're not talking about a college student, submitting a portfolio. If you're just talking about a second grader trying to apply to the local elementary school, how do you employ a holistic admission standard? It's much easier just to assign students based on race. But the Supreme Court has said you can't do that. So instead, the Supreme Court has said in a similar case that we describe in the book, the Seattle and Louisville cases, they can use proxies for race. They can use poverty measures. They can use geographic measures, anything that might serve as a decent substitute for race, but without considering race itself. And they can try to achieve diverse schools in that way. So it's challenging for school districts, but there's still a way for them to do that. And fortunately, after Fisher, that still is a possibility. So that's the lesson from Fisher, and that's a little summary of Chapter 6.
And we want to allow a few minutes for questions before the day ends. So what we'll do is we'll take a few questions, and I'll repeat the question into the microphone. That way we capture it before the webcast, and then the scholars will address the question. So there was a lot to digest there. Any questions from the audience?
Yeah. Coming from a total non-lawyer, is there any underlying principle or principles that link these various elements together? They're all about education, but is there a more general principle or set of principles or lens through which to view all of the various elements, disability, affirmative action? Can't remember all of
The question is there a general underlying principle that unites all of the discussion topics, particularly First Amendment rights, disability rights, affirmative action?
Well, that's it's true that we cover a lot of terrain, and in the 12 chapters, and it is hard to describe a sort of common thread, except that we are dealing with K-12 schools within which most students are children, minors. So the idea in 1969 that the proposition that children do not shed their constitutional rights at the schoolhouse gate, I mean, that's something that I've wrestled with in my studies. What rights did they have to leave there in the first place? To my mind, they leave their parents at the schoolhouse gate, and not really their rights. But that's not to say that children in K-12 students don't have rights. They do. The Supreme Court next door has said so. But the court has always said that those rights are not coextensive with those of adults in other contexts. So if there is a unifying theme, is, well, how do we apply the concept of rights to, that we understand in the adult world beyond the schoolhouse gates to this context, this educational context, public and to some extent private schools, when we have minors or children, when their interests are implicated.
Yeah, and I think just to build on that point, we see that in the federal statutory arena as well, where the aim really of these ADA amendments was
For workers.
Was for adults. That was the primary focus, and yet students are the beneficiaries of that. And it's more challenging for schools to try to figure out how do we apply these worker-centered rights to minors, but the minors still are covered. So just as Jason said, just as they are in the constitutional realm as well.
Any other questions? I actually had a question which I was wondering if you guys could address. Are there parallels? The school environment seems to be quite unique. Is there a sort of parallel environment, the home environment, or public recreation environment, where maybe there are some precedents that are set, or where things from the school environment apply or deviate, or just generally if you could address that?
Well, it's actually, schools have been described by some legal scholars as mediating structures. So they're not totally akin to the home, and they're not totally akin to public institutions, other public settings. And again, this relates to the fact that we're dealing with minors, so that young people who are not yet fully competent. They're at some, depending on their age, of course, and level of maturity, they're not yet fully capable of exercising certainly liberty rights in the way that we understand adults, normal adults, are competent to exercise liberty rights. And so young people as minors are categorically excluded from doing all kinds of things out in the real world, from being out on the streets at night in municipalities with curfews, to buying alcohol, or driving if they're under 16, right? So we have this category of persons, minors, children, who are excluded from exercising the kinds of rights, including rights of speech and mobility and so on, that we take for granted as adults. And this does get to broader questions about the purpose of schools, education generally. That at some level, schools exist to provide public access, children with access to public knowledge and to diverse ideas and so on, to help cultivate the capacities that we associate with legal competence, and that rights are designed, I suppose, to recognize and protect. So I don't think it's coincidental that the school leaving age is generally 18, the age of a majority. That's not a coincidence. Would you add to that?
No, I think you
rambling
captured that.
response.
Yeah, no, that's good. Right.
Great. We have time for one more question. If anyone has anything in particular that they want to ask, yes, please.
Almost daily we see on the news some idiotic rule that a school board has set in. This morning was a 6-year-old who kissed a girl who was suspended for sexual harassment. And there are other things that we all know of kids pointing their finger and saying power and getting into trouble.
Finger guns.
Right. I don't remember these things from the past. Is there some reason why these have appeared, and is there any way that they can be stopped?
So the question is about
I saw that.
boards,
Yeah.
School boards, and
could-
regulations and
Sure.
restrictions such as kissing on the schoolyard or pointing a finger gun at people, and what the implications are.
Well, we both saw that from Jonathan Turley's blog this morning, the account of the 6-year-old who was suspended for kissing a fellow student's hand, so accused of sexual harassment and being a sexual predator. And the stories of the finger guns and what have you. Apparently, we're told that zero tolerance policies are on the wane, and stories like this one would give some doubt that that's true. In relation to what I said earlier, one of the difficulties with zero tolerance, and we do address zero tolerance in the textbook, is that zero tolerance policies remove the element of discretion from school officials. So the school officials, instead of exercising good judgment and assessing the situation in light of the circumstances, the age of the child, level of maturity, the nature of the infraction, that they simply say, this is sexual harassment, this is violence, this is a weapon, and apply the penalty. A problem philosophically here is that if schools exist in order, at least in part, to provide children with exemplars of good judgment exercised on their behalf, so that by the time they reach 18, they can do likewise, exercise good judgment for themselves as adults, then schools are, especially schools headed by principals like this one, who clings to a zero tolerance policy, then they're not going to be doing that. And sure, that's a problem. That's a problem.
And I would just say, just in fairness, the flip side of these stories, there are unfortunately very serious incidents of harassment that really do occur, that are very serious, and
Yes.
those tend not to be maybe sensationalized as much in the press as these sorts of rather ridiculous examples. But for example, when students are assaulted by teachers, or serious assaults by other students, but in those cases, it's a pretty high bar. I mean, there has to be a very serious assault before a student at least can sue the school or the other student's family for money damages. So there is at least some sort of reason, I would say, in the system is not totally out of control. But certainly these examples don't look good, I would say, for the schools.
Thank you, and thank you guys. Let's give our scholars a round of applause, please. I wanted to briefly remind that we do have copies of education law for purchase on the way out, and if you would also quickly remind the folks about the other volume that you've put out that we don't have today.
A companion volume that's smaller and cheaper, called A Teacher's Guide to Education Law. It's a more sort of pocket size.
So we don't have that one available, but you can certainly Google it or check it out from your local library, perhaps. And on the way out as well, please do sign our RSS list to learn about future events and other scholars and residents. So thank you again very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.